introduce you to John Lund. Has been a practicing family law attorney in central Minnesota this is his 45th year. He's somebody that I've trusted my family with, and just because of his vast knowledge and having been in the industry for so long, it's great that he's willing to share his wisdom with us, and he's super kind. He's been here twice. He's spoken with single moms for me, and so I'm going to let him just take it away. I know some people put in questions. He's going to do his best to answer if he can. Some of it is a little bit hard just because every scenario is so very different. So I do have his phone number up here. If you are interested in scheduling an appointment with him, you are welcome to do that. But with that, welcome.
Thank you. I'm here because I like Amanda. So I've known her for a while.
Yes.
Like she said, this is my 45th year. Couple of things. I never thought I'd last this long. I never thought I'd live this long. But I have, and I've continued to do family law, which is unusual, I think. There's a lot of people that burn out on it rather quickly. It's kind of emotional. It can be difficult now. So what my thought was, in just kind of giving an introduction into family law, was to kind of give you the history as I've seen it over the course of the last 45 years. We now have a system that has legal custody and physical custody. Legal custody didn't even exist when I started. Child support guidelines didn't exist when I started. Legal custody became a thing in 1982. And in 1982, they decided that both parents should continue to have something to say about major decisions regarding their children. And that was like a big deal at the time. Dads got custody 5% of the time. I mean, it was extremely rare. And the law used to say that joint custody should only be granted in extremely exceptional circumstances. I had a case, and this was a long time ago. I still remember it. It was in Sherburne County, and the couple had a couple of kids, and they split up, and they actually bought houses next door to each other so that the kids could go back and forth. And they said, we're better friends now than we ever were when we were a couple, and we want to have joint physical custody. And I went down to the court, and the judge said, I can't grant this. I can only grant it in exceptional circumstances. And I said, well, Judge, we're going to take some testimony here, and I'll prove this. And they testified for about an hour, and in the middle of this testimony, the judge says, okay, you've convinced me. Okay, but that's what it used to take. And now, 40 years later, that's almost become the norm. Now I think the judges take a look at it, custody study workers take a look at it, and their starting point is, okay, why shouldn't these people be sharing their children equally? Is there any reason that they shouldn't? And that seems to be the starting point. All of this kind of progressed from a time when the judges were born in the 20s and 30s, and people didn't really have much of a background in terms of the impact that divorce, and I'm going to talk about it in terms of divorce, because the idea of single parents from unmarried couples to the extent that it is now just didn't happen 40 years ago. Okay, this is all pretty new. I saw something, I think it was about 6 years ago, and it was the first year in history where more children were born to unmarried couples than were born to married couples, which was an extraordinary circumstance in my mind. So when I talk about things, I talk about divorcing couples, maybe out of habit, I guess. But at the time, dads got custody maybe 5% of the time, and they got every other weekend and alternating holidays and see you later. What's your child support going to be? And at the time, child support was, some of these guys would go, well, I'm not paying more than $25 per month per child, and that's all it's going to be. And so they came up with the child support guidelines, and they've changed over the years, over and over and over again. And so now we're in a situation where most recently there's a presumption that even a non-custodial parent's going to have a minimum of 25% of the available overnights with the kids. Okay. That's 7.5 overnights per month average. So is that more than every? Well, that's more than every other weekend. That's going to involve some weekdays. That's going to involve some problems with transportation. That's going to involve some problems with school. That's going to involve all of those things, and they all have to be considered. I think one of the biggest changes that occurred in 1994 when it was decided that everybody needs to undergo alternative dispute resolution before you can get into court. There's some circumstances where it isn't required, but for the most part, ADR is required. That started in 1994, and since then, in a family law context, I've never seen anything used other than mediation, and mediation is nothing but a facilitated settlement discussion. How are we going to do this? Things are done in terms of meetings in the middle. Okay, not everybody gets everything that they want. And one of my warnings to people is, even if you go to court, you aren't going to get everything that you want. Okay, everything's kind of a compromise. There's two parents involved. And essentially, I think what happened over the years, there was a judicial commission that studied custody in Minnesota, and they made the determination that children are best served having as much time with both parents as possible and having both parents involved in their lives. So when I talk about this being a presumption, this 25%, it's a presumption, but that doesn't mean that it can't be overcome by evidence. And most notably, the evidence and the restrictions on parenting time involve situations involving mental health, chemical dependency, abuse, physical abuse, more than psychological abuse. I see a lot of times psychological abuse being emotional abuse being alleged. But boy, nothing's harder to prove. It's hard to convince somebody that they can't see their kids because they're jerks. Basically, that's the way that I term it. They're emotionally abusive. They're jerks. And I'd use a different term, but I'm in a church right now. So they're more than that. And so what can your expectations be? My advice to you is find somebody that you can talk to, find somebody that you feel comfortable with, find somebody that has a background in this and knows what the heck they're doing. Don't take your legal advice. I used to say, and this was back when I did criminal law too, I'd tell my clients that they get their worst legal advice from whoever happens to be on the bar stool next to them. And that was pretty appropriate in a criminal law context. I'd say now you get your worst legal advice from whoever you happen to be talking to, or the internet. Well, if any of you are medical professionals, people get their worst stuff off of the internet, right? It's the same thing with regard to law. So be careful. Go see a lawyer. Lawyers give free consultations. They'll sit down with you for an hour, and they aren't going to charge you a dime, and it's worth your time, and it's worth your effort. And if you have to take a morning off of work, for Pete's sake, do it. Don't be stubborn. So with that, maybe I'll try and answer some of these questions.
Sure.
What legal rights does my husband have as far as getting temporary custody of our 15-month-old child as an undocumented? I left because of abuse, and I have concerns you will flee with our child to Mexico. Do courts typically order supervised visits in these cases? This is the first question. I have no idea. Okay, all of this stuff, nobody cared about undocumented immigrants up until 8 months ago. And now everybody's up in an uproar over it. I don't know what the outcome of it is. I would think that someone who's not documented might have a real fear about going into court, because all I hear is stories about the ICE agents being there in court waiting for them when they get there. That becomes a problem. I don't know what a judge would do with that. I've never seen that happen. But the idea that the last sentence, do courts typically order supervised visits in these cases, is really kind of intuitive, because I think that that's what the remedy is to that. Is, okay, well, we want you to see your kids. We want you to see your 15-month-old and have some time with your 15-month-old. But that would be the remedy, is to make sure that his visit is supervised so nothing untoward happens. I don't know what else to say about that. In terms of parenting time and parenting plans, everything related to that. As I said earlier, I think it's about compromise. And I think the worst thing that people say to me, and it happens, it's the most common thing that I hear, well, that's not fair to me. And well, it's not about what's fair to you. That's not what any of this is about, is what's fair to you. It's about what's fair to your kid, what's fair to your children, and what's fair to both parties. You're in a situation where the toughest thing, probably the toughest decision that you faced in just breaking up your relationship, was knowing that you weren't going to have your children with you 7 days a week. And now you're facing that as a set of circumstances. And now that's where you're at. So that's where the compromise is going to begin. And those parenting plans are all over the board. And they vary in some cases according to what each parent's needs are. I look at the schedule of each parent and the schedule of the children. And what are the kids' schedules? Because that's important as well, because you got to take that into consideration and try and balance all of that stuff out. There's circumstances where, this is going to sound sexist, dad is a construction worker, okay? Dad's a construction worker, and doggone it, when summer's around, he gets up at 5 o'clock in the morning and he's gone before the kids are out of bed. And he doesn't get home until dark. And he sleeps for 8 hours and he's gone again. And he's just not present. But now with Thanksgiving coming up, it's the end of the construction season. And doggone it, between now and Easter, he's going to be around all the time if he isn't ice fishing. Because that's what happens most winters, is the construction workers go ice fishing. And so that schedule takes that into consideration. I see a lot of people that work for Centricare, and Centricare's got a lot of its employees on 36-hour schedules, 312s. So how does the scheduling go? It kind of accommodates that. What are the kids' activities? What are they involved in? Has dad been involved in scouts with Billy? Well, what night scouts? Because dad's going to want to have scouts and have Billy on the nights that Billy has scouts, and we're going to take that into consideration. All of those things are things that kind of work into it, and it is about compromise. And my experience is the last thing what judges want to do is decide parenting time. They don't want to just tell you when you get to see your kids. And they don't want to give you a schedule that's inconvenient and that's going to cause problems. They want you to figure it out. which is why they force you into mediation. Yeah, you go in there before you go to mediation, and you've got a parenting time problem. They're going to tell you to go see somebody else before we get there. Is there any way to avoid supervised visits when establishing parenting time with a 17-year-old? I'm not understanding that question because I don't know if, well, there's no need for supervised visits unless the child's endangered in some way. If the supervised visit is being established in order to make the 17-year-old go to parenting time, that's just such a huge problem these days. There's a lot of kids that just absolutely refuse to see one parent or the other. One of the old judges told me years ago, I'm not going to go pick up that kid and put him in the car. It's not my problem. I don't have a solution for that. And there is no solution for that. I've got a case. Well, I have several cases right now where the kids just absolutely refuse to see a parent, and there's no solution to that. So I guess that's my answer. My divorce decree from 6 years ago states he pays 40% and I pay 60%. I'm assuming that's a reference to the child support guidelines, which base child care expense, insurance expense, and uninsured medical expense on each parent's share of the joint income. So if 6 years ago it was 60-40 and it's no longer that anymore, child support, insurance payments, uninsured medical expenses, daycare expenses are all subject to modification at any time based on changes in circumstances. There's a statute that says if things change by $50 a month, it's a significant change in circumstances, and you can get a change. The other thing I would tell you about child support, I can't tell you the exact year when they did this, but they came up with an expedited child support system, which judges, well, this is me. Some of the judges thought they were too darn good to be establishing child support according to guidelines. Okay, why should I be sitting there and doing the math? So we're going to get we've appointed child support magistrates that hear nothing but child support cases. All of the forms necessary to modify your child support is available online. All of the instructions are there. You don't need a lawyer for it. It's completely unnecessary. Or there's a 4D section if in Stearns County, it's the administration center by the courthouse. Thank you. and you can talk to the child support people if you're receiving any kind of child support assistance of any kind. They can represent you, but they're overwhelmed and they're going to be really slow, and you might find that you're better off doing it yourself.
There's a lot of stuff you can file for on your own, though, right?
Yeah,
go down to the courthouse.
All of the forms are there. MnCourts, I think it's mncourts.gov, mncourts.gov gets you right to the Minnesota courts website. There's a tab up top that says forms. I use them. Lawyers use them. Everybody uses them. They're available. You can check it out. Having said that, I'm always reluctant to tell people to do anything without a lawyer. I've seen people just get smoked for no reason when the other side had a lawyer and they didn't, because number one, I saw a poll in USA Today about 20 years ago that lists Americans' greatest fear, and I was just dumbstruck. Their greatest fear was public speaking. More people were afraid of public speaking than were afraid of death. Which so now you're going to go into court and you're going to see a judge and you're just going to clam up and it's going to drive you, yeah, and you're going to feel foolish. Do you have any advice regarding order for protection evidence? My rule with regard to evidence is the people that are involved in this action have the least amount of credibility because they've all got an axe to grind. They all want to see a certain result. So if you're going to make a claim, anything that you can have to back it up that isn't you is going to be helpful. I prefer documentary evidence, something in writing, something on video, something in a photograph. Those are all the best evidence. Third-party evidence is also good. But if you go in there and it's he said, she said, the judge is going to go, I don't know, I don't know who to believe. I don't know who to believe. The other side of it is, in orders for protection, my opinion again, judges are going to err on the side of issuing the order. Okay, they've had some very bad things happen to people when they fail to issue them. And the amazing thing about orders for protection is they work. I mean, they really work. It's amazing to me that you'll have an abusive person that feels that they can get physical and push somebody around, but the minute there's a piece of paper saying you need to stop, that they stop. I mean, how stupid is that? That doesn't make any sense at all. But until somebody tells them to stop, that they just keep going on as if nothing's going to stop them. I have an order for protection in place. Is there any way to find out if dad is on disability or anything to establish financial support? He hasn't paid at all. Forms are available online. Not only that, but he's going to be required to disclose all of his assets and all of his sources of income as a part of that process. If he doesn't, the court can impute income to him based upon, the statute applies, and I'm going to go with 30 hours of minimum wage per week is going to be the least that they're going to base support on, because they're going to decide that he has the ability to work to that extent. That's off the top of my head. Beyond that, if there is a work history and an earnings history, and you can show the earnings history and he fails to show what his earnings are, they can use the earnings history as a basis for establishing support as well.
Can I ask you a question about that?
Yeah.
So for disability, like, can they take child support from a disability check or income?
That's a good question. I tend to believe they can. That's something I'd have to look at. But I think that they can.
My family lawyers. Yeah.
Yeah.
Yeah, because at first you thought my soon-to-be ex was on it, and I'm like, no, he was in the past.
Okay.
So he said, well, that'll make things easier if he's on disability.
Yeah. I think the thing that you've got to remember is you don't have the right to the support. Your kids do. And there was a case, and it goes way back. This is off the top of my head as well, but I remember a case where the kids hadn't been supported for like the last 6 years of their minority, and mom never sought support. So they sued dad for 6 years of back support. And the court said, you know what? The right to support was yours. It didn't belong to your mother. She can't make that decision. And there are situations where mom is not allowed to waive support in the event that there's back support that's due, because that belongs to the child. So that's kind of a nifty. I like that. The right to support belongs to the child. So support your kid. What do I need to do when an absent parent threatens to try for custody after years of absence? Tell them no. No, you're not going to get custody after years of absence. And really, what happens in terms of that, when I'm representing someone who's as a parent that's been absent for a number of years and now suddenly appears and wants to be a parent again, is, you know what, you're going to have to prove yourself. You're going to have to do it incrementally. You're going to see this child. I mean, some of these guys show up, and I say guys, they show up, they've abandoned the child when the child was a year old, and now the child's 6, and they want to be dad. And I go, okay, how does your kid know I'm not the dad? The kid doesn't. The kid doesn't know that I'm not the father. So you're going to have to prove yourself. You're going to have to start seeing him, and you're going to have to start being a dad 1 hour a week. And you're going to do that for 6 weeks. And then you're going to get 3 hours on a Saturday afternoon. And we're going to work at this incrementally. And you're going to have to not only prove yourself that way, but you're going to have to be consistent. You aren't going to be in a position where you decide, well, deer hunting starts this weekend, so I can't show. No, you're going to be dad, and you're going to be there, because if you miss, you're going to start over again. That's kind of how I've done it in the past. Yeah.
I have a question off that then. So if you are allowing them to try incrementally a few times and they end their schedule because they're upset that they can't have a relationship with you, there is no parenting time order or anything in place because we were not married. At what point do you end that for the best interest of the child if he keeps just ending his schedule because he's not getting his way?
Yeah, well, that's a good question, and I think that's something you decide based upon your child's reaction to that, perhaps. And what's your kid's reaction, and what's the child's response to that? Is it very upsetting? So I need to do something. Minnesota still, and I think this is a little backward, and maybe will change. But if parents have not been married, even if you've done a recognition of parentage form, if there's not a judicial decree establishing parenting time, mom's the custodial parent until a judge says she's not. And so mom holds all the cards, and mom gets to make the decisions. The difficult position that you're in at that point is they redid the custody statute, which is Minnesota Statute 518.17, lays out the factors the court's supposed to consider in making custody determinations. And some of those factors were changed 8 years ago to talk about both parents' willingness to encourage the child to have a relationship with the other parent and not interfere with the other parent's parenting time, and to do those kinds of things. So now you got to now when I'm talking about that without having particulars, I've got to kind of balance that with the idea that some judge down the road might say, well, what the heck are you doing keeping your kid away from him? And so that's why I say what I do. I don't know if that's a good answer or not, but
Yeah, there's more details of like he wasn't around for about 8 years.
yeah, well, he needs to.
Coming in and like I'm allowing every other Saturday for 7 hours, and then he ends the schedule with her because he's not getting his way. And I leave the schedule open. Like you absolutely can keep trying with her and with our son, but he ends it with her.
That sounds more like a boundary issue with you.
We have
Yeah, you think you get. Yeah, I think you got to say no. I mean, without getting into too much detail, a lot of times it's just a lot of custody issues, and I haven't said this yet. But a lot of what I'm seeing in terms of custody issues and parenting time issues aren't about parenting time or custody at all. They're about control. And it's about the control and the relationship. And it's like, no. There just comes a point where you just say, it's line drawing. No.
Well, I mean, other states are moving towards automatic 50-50.
Yeah, and it comes up in the legislature every 2 years. Where they want to presume 50-50, and it's going to happen.
Absolutely. And statistically speaking, like this is something that I've shared if you follow social media, that statistics prove that children and parents, single parents, do better when custody is split 50-50. So,
Which custody, legal or physical?
Oh, physical. We're talking parenting time.
Parenting time right now.
We're talking equal time. What you call physical custody doesn't matter anymore. You can call it joint physical custody, and dad gets to see the kids every other weekend. Yeah, what you call it doesn't matter much. All it really matters is what the parenting time is. But when Minnesota talks about it, it's not an absolute, it's a presumption, which means it can be overcome by other evidence. So what's the other evidence? Inebriacy, chemical dependency, methamphetamine, mental health, opioids, it just goes on and on and on. I used to, when I had people interview for jobs, I'd ask if they'd ever worked in a law office before. And if they said no, I would tell them that they should probably think twice about whether or not they want to do that, because they're going to be exposed to parts of life that they might be much happier not knowing about that's out there. And I'm talking about those 5 things at least that I just talked about that interfere with that equal parenting time. Last but not least, how can I legally protect myself from the ex-in-laws, parents, child's grandparents? How long will CPS case stay on record? I don't know. I think it stays on record forever. And I would hope that they don't take it off the record, to be honest with you. I think it should stay on. It's kind of like DWIs. You don't get rid of those anymore. Wouldn't a state planning attorney or family law attorney be best for setting up a will or trusts? An estate planning attorney. Don't trust a family lawyer with that. Get somebody that knows tax law. Can a step parent assume guardianship when a biological parent is deceased or terminated parental rights? There is an action called third-party custody, where a third party, whether it's a grandparent or an interested party or someone, let's call it an interested third party, can seek custody of a child. There's certain requirements that need to be met in order to do that. And the standard is clear and convincing evidence, so it's difficult to do. They make it difficult to do because in the year 2000, the United States Supreme Court decided that parents have a constitutional right to their children, and they can only be taken away in exceptional circumstances. So, yes, third parties can get custody.
Yeah, but grandparents also have rights. So in the case where a parent passes away, then those parents would have, because they would have some rights. So there is legal visitation.
Correct. There's grandparent visitation, and they can bring an action to intervene in a case in order to have grandparent intervention, grandparent visitation. I've got several of those right now.
Yep.
Yeah, that can happen.
Yes, and that can get kind of dicey. So I think some of the question is like, how does a living parent protect themselves from the grandparent who maybe wants to overstep boundaries, or
Well,
I mean,
here's the
because
pro-
they
here-
get parenting time,
yeah, here's the problem.
but
Okay?
where's the line?
I don't know where the line is, and I don't know that a court is a place to establish it.
Mm-hmm.
I don't think judges are not going to micromanage people's relationships with their children. I get people that I don't want him to have these kids anymore. They don't have. He lets them stay up until 10 o'clock on weekends. Okay, too bad. Dad's going to let the kids stay up till 10 o'clock. He's going to have different rules in his house than you have in your house. When you're in a relationship and you're in the same household, it's compromise again, particularly among men and women, and particularly when sex is involved, because you know what? I'm mad at you, right? So you do things as a couple and you compromise as a couple, but when you aren't a couple anymore, that compromise is gone and people treat kids differently, and the court's not going to micromanage that.
Well, but mediation hasn't always been a first line of defense. When did that become the most common?
1994.
Yeah.
I actually looked it up. I looked it up sometime in the last month because I keep going. I can't remember when that happened, but it was 1994. And the first mediator around here was a judge who'd been in his mid 70s, Paul Hoffman, who had been a judge since the 1960s. And judges are forced to retire at the age of 70. And so he became the go-to mediator.
Mm-hmm.
And Judge Hoffman, I still quote Judge Hoffman, he'd tell people at the beginning of mediation, this is not about happy. This is not about everybody getting everything that they want. This is about compromise. If I see any of you walking out of here with a smile on your face when this is done, I will know that I've failed.
Oh, yeah.
He was great.
Yeah, I mean, that's a great tip, though, as far as mediation. Do you have any other tips for mediation? Like, that's a requirement now. So what should we expect? We should expect compromise.
You should expect compromise. It's all about compromise. And mediators are going to tell you some of the things that I've already said. And they're going to try and convince you that the important thing here is for you to reach some kind of an agreement, because you don't, otherwise you're going to go to court, you're going to have a trial, you're going to put all this evidence in front of the judge. He's going to think about this for about 30 minutes, and he's going to decide when you get to see your kids. And sometimes I got a decision Thursday from a case that I tried in August. And everybody's been waiting for 3 months to try and find out what the heck's going to happen.
Mm-hmm.
And so they're going to tell you about the importance of reaching a decision and not going to court if you can possibly avoid that in any way, shape, or form. What the interesting thing is, mediation didn't start out being done this way. It used to start out with, they used to call it a kumbaya session, where everybody would go sit around the same table, and they would talk about how important it is to your children and how important this was and how important this was, as opposed to getting down to brass tacks right away. And then there's still, in the Twin Cities, there's still mediators that'll have us sitting around the same table and presenting our position to the other side. And I had a situation really, really early on where I discovered that nobody can push each other's buttons like people that have been living together, than married couples, than couples who've been cohabitating. It's like, oh my God, somebody said something, this woman said something to my client that sounded completely innocent to me, and he went across the table after her. And I went, no, we're not doing this anymore. We're going to separate rooms. And I've been in separate rooms ever since. There's a presenter from California that's a mediator trainer who said there's only 3 states in the United States that do things in separate rooms, and Minnesota is one of them. I do it in separate rooms. Most times I don't even agree to sit around the same dang table.
So you said only 3 states go in separate rooms?
Yes.
Otherwise, the rest.
Otherwise, we're all doing kumbaya. Yeah, it's insane.
That's what's coming up next for me. And I had heard a friend of mine had told me they were in separate rooms, and then maybe they would go back.
That's how we do it. Yep.
But I'm being told we're going to be in the same room.
Where's the mediation?
That's being.
I don't need specifics. I do just regular kind of areas.
Like, you mean location?
Yeah.
St. Cloud
Oh, it's in St. Cloud.
or Albertville, but I think this round is going to be St. Cloud.
If it was Albertville, I'd understand it more than St. Cloud. I don't know of any mediators in St. Cloud that do it in the same table.
Can you request to have it in separate rooms?
I demand it. Yeah, I just go.
So if you're headed,
I just think it's really uncomfortable. It's really uncomfortable for people to sit in the same room. And it's not constructive.
It's intimidating too, depending on if there's a power imbalance as well.
When they talk about that in terms of you're not required to go to mediation, you're not required to go to alternative dispute resolution if there's been physical abuse in your relationship. It's just not required. And that's why. Now, there's other imbalances that exist, and separate rooms are one way of resolving it, but also having a lawyer with you. There's a lot of clients that I've gone and said, tell him your lawyer says no. Because my client's been incapable of saying that. So I'll take it. I'm the one saying no. You don't have to be the person saying no anymore.
and you can bring support people to mediation, right?
I hate it. I do not like it.
You don't like it when somebody brings a loved
I
one?
do not want. Third parties sometimes get in the way, and they start expressing their opinion. And now I've got a client sitting there that really, you don't know if they're trying to make a decision on their own or if they're trying to please this other party. I mean, there's a whole dynamic there that I like to avoid.
Yeah.
Yeah.
Good to know. All right. Any final thoughts? We're going to wrap up, but is there anything else from all your years of experience that you would say, this is what I really want people to know as they go through this process?
I think I can't think of much that I've missed at this point.
Good.
That's pretty good.
Okay. Well, we're on time. Awesome.
Okay.
Well,
awesome.
Thank you, John.
Yeah.
Thank you.
Yeah, well, it's fun.
All right.
Nice meeting you guys.